Hi everyone. Today I'm going to speak to you about the filing requirements for condemnations. Condemnations is quite interesting in the tribunal because it allows for deviations from the tribunal rules. So we'll spend some time going through a little bit of the filing requirements and the purpose and when condemnations are being used at the tribunal. The first slide is titled, What is a condemnation application? And really to understand it, we must know where it comes from. Condemnation comes from the word condone. And condone effectively means to pardon something. So legally speaking, it's pardoning a non-compliance. In the tribunal specifically, it's either pardoning something that is not done in line with the rules or not done in line with any other provisions of the tables that guide how we need to file. It's to do with not filing an answering affidavit in time. It's to do with not filing a replying affidavit in time. It's to do with extending time to do a replying affidavit or an answering affidavit. So a condone is an interlocutory application that exists within an application that seeks to try and condone or pardon something that has been done that is not 100% aligned with the ways things should be done. Interestingly though, condemnation applications are not found in the Consumer Protection Act. It's actually found in the rules of the tribunal, and it's important that it's found there because the rules of the tribunal is the vehicle to access the tribunal. So because it's a procedural issue, condemnation applications can be found in the tribunal rules. We find it under Section 34. Rule 34. Rule 34 provides 4 different types of condemnation applications that can be filed. It's limited. The first one is to condone the late filing of a document or an application. I'll give you some examples earlier, but I did mention aspects such as answering and replying affidavit just before this. Condemnation application to extend or reduce the time allowed for filing. From experience, I haven't had any single condemnation to reduce the time allowed for filing, but I have had condemnation applications to extend it. Condemnation application to condone non-payment of a fee. You find that where exceptional circumstances exist, you apply for a condemnation in applications where a fee is required. Last one is condemnation to condone any other departure from the rules of procedure. This is an interesting one because this one allows for any other in that it's not limited to a specific type of condemnation, but rather a condemnation that cures a defect that exists in terms of the process or rules that have been followed. Condemnation application seems very complicated. What I'm here to do is try and make it less complicated, or a quite simple way of understanding what it's used for by using practical examples. So you know when an application is filed, an answering affidavit from the previous video needs to be filed within 15 days, and a replying needs to be filed within 10 days. So the first type of condemnation is the condemnation application to condone the late filing of a document or an application. So the example I'm going to use is the answering affidavit. So say for example, the condemnation application, the application was filed with the tribunal about 25 days ago. And you as a respondent didn't have time to answer to that application, but you do want to in fact answer to that application. What you would do is you would file an application to condone. You'd attach your answering affidavit in that application to condone because you are asking for the late filing of an application. That is not the only way in which you can deal with this. The second aspect is condemnation application to extend or reduce the time allowed. So if we think about the same example where you haven't filed your condemnation or your answer in time, you're entitled to make a condemnation application to extend the time required for doing that. In that instance, you don't need to provide a condemnation, you don't need to provide an answering affidavit. You need to provide a date in your document as to when the answering affidavit will be provided, and then provide it on that date, irrespective of whether the condemnation application is granted or not by the adjudicators. If it is granted and you did file within that time, then only would the condemnation application be part of the pleadings of the matter. In the other instance where we spoke about the late filing, yes, you will get condemnation for the application for late filing of an answer. The condemnation will have to be adjudicated on. It's only after the granting of the condemnation itself that the answering affidavit falls part of the pleadings. Because we used an answering affidavit as an example, the pleadings will close 10 days thereafter, or at the point that a replying affidavit is filed. This slide captures the last 2 types of condemnations that can be filed. The very, very vague one in the sense that it deals with departure from rules of procedures, and a specific one dealing with non-payment of a fee. The tribunal in some of its applications has a prescribed fee. However, a condemnation application can be made to waive that fee. So you'd see waiver application, that would be basically in the form of a waiver. So you'd request a waiver in your condonation application, and that would result, or could result if granted, in the fee being waived when you're actually filing the application with the tribunal. There's not too many applications that are received by the tribunal that requires fees. The ones that I can think of is your section 138, 138A or 1A, which is your debt review applications. There is a couple with regards to objection to compliance notice where a fee is required as well. Substantial reasons would have to be provided, and that would be contained in your condonation affidavit. In terms of condonation application, not to condone any departure from the rules or procedures, this was an interesting one because we've had examples of this. We've had many types of examples of this, and I'm going to give you the scenario in which led to a filing, for example, of a supplementary, or some call it a rejoinder affidavit, depending on the circumstance. So the example I'm going to give you is, say for instance, an answering affidavit is filed by a respondent, and the applicant is filing a reply. But in the reply, or in the answer, different elements have been raised, or in the reply, different elements have been raised, or certain elements in the answering affidavit was not catered for. Maybe there was additional information that was found out that's not in there. Now, under those circumstances, a party can file a supplementary affidavit, but the rules don't cater for the filing of a supplementary affidavit. There's no speak of a supplementary affidavit. They speak of an answering affidavit and a replying affidavit. So you would file a condonation to depart from the rule of answer and reply to file a supplementary answering affidavit or a supplementary replying affidavit. A rejoinder is an example we've had recently where after the reply was dealt with, the party decided that they actually want an opportunity to answer to that reply. And in that instance, they filed a rejoinder affidavit. Again, these affidavits do not become part of the record at the time of filing. It becomes part of the record only in the event that the condonation is granted by our tribunal. Okay, so far we've covered what exactly a condonation application is, or what is a condonation. We've then gone on to discuss the different types of condonation, but now we're here to the critical thing, and this is the one that affects you most. It's how do you file a condonation application? What do you need to do? So the most important thing is to understand where it's coming from. The tribunal rules, which is found on our website, has a table B towards the end of it. Within the table B has a list of requirements that is required for the filing of a condonation application. These requirements specifically is a Form 30A, which is required, an affidavit, a condonation affidavit specifically, which is required, and a Form 34. The Form TI-34, sorry. The TI-34 is basically an application form for condonation. The Form 30A is basically a notice of filing, or not a notice of filing, it's an index to your application, or your filing notice. An affidavit is a document that has become commissioned and has become an affidavit. It's something that binds your conscience when you are signing it or deposing to it. So I'm just going to take you through some of, in this slide, the Form TI-30A, some of the common errors, the affidavit that we have, some of the errors that we find, so you don't make those same errors. So in the Form 30A, which as I said, it's just purely a filing notice, it's A versus B, in the matter of A versus B, and then it goes on further to say, I am filing document A, B, C, D, E, F, G, and it's important that it has that, and the importance emanates from the reason that the person receiving it must confirm or must be aware that they're receiving a certain types of documents or certain documents. So the Form 30A is an incredibly important document, especially when it comes to service, which we'll touch on just now. But Form 30A, issues that we've encountered in the past is citations. Now remember, citations is important. When you're citing a respondent or someone you're complaining against, it's important to get the citation correct, because the tribunal can issue an order in your favor, but enforcement becomes a challenge if the order is against a company that may not exist or a business that may not exist. So it's important that you understand that you cite the company that you're dealing with properly, whether it be a PTY, an LTD, a closed corporation, whether it be a private individual, whether it be a partnership, that the citing takes place. Following that, on the second page, the respondent's full details is required. That needs to be filled in. I often find that people just miss that page out. Now again, when dealing with citations, it's always difficult, because if the citation is not included in the company documents, it's very difficult to find. What I use is the CIPC website. The CIPC website is available, and it allows you to ascertain company registration names or numbers. It gives you the details, so you know that the person you are complaining against is actually the person involved in the matter. An affidavit, so a condemnation affidavit. So if you're filing late filing of an answering affidavit, you need two affidavits. You need the answering affidavit plus the condemnation affidavit. Why are you filing the affidavit? It's because you need to state why are you filing late? Why should we be condoned? What is the importance of the matter to you? On a balance of probabilities, what is the prospect of success for you in this matter? Things like that is important to be addressed in your condemnation affidavit. The common errors that we find is, remember, an affidavit is not a document simply signed by you. It's deposed to by you, and a commissioner of oaths then has to confirm each and every page. So what we find is the affidavit sometimes is not initialed on each page, even by the deponent or the commissioner. That doesn't become an affidavit if it fails to meet those requirements, and because of that, whether you file it with us or not and call it an affidavit or not, we can't accept it as an affidavit. Affidavit should be, as I've mentioned, address the background of the matter, the prospects, the reasons, the extent of the delay, the importance. Quite importantly is the prejudice will suffer if you do not get granted that late filing. The affidavit, often it does not cite area and dates that it was commissioned. That's important because we need to know when it was commissioned. When it is commissioned is important to when the case had occurred, so that is quite important. In those two documents, it's quite important. This is your crux. Your affidavit is your crux. It's your case. So you need to focus on getting this right and making sure that it's detailed enough for your condemnation to be granted. Because remember, it can be opposed by way of a condemnation answer. It can be replied to. It will be adjudicated on before a decision is made. Okay, so this is the last slide. It's the final bit of requirements that's required that I've just touched on. So the next form is your form TIR34, and I remember I told you this is important. This is your application form. So it's important that you fill the details in correctly and in as much detail as possible. Again, we have an issue where there's a citation on this document for a respondent generally or another party. It depends on how we're dealing with the case, which is not consistent sometimes, or sometimes it's just the wrong citation. So remember, make sure that the citations match. Also make sure that you've checked the citation. It's again another application. You are making an application to someone, you need to sign it because you need to be making that application. So that signature on that document is also important. So that form TI-34, those are the common errors we find. Generally, we find people do put a lot of detail and good detail in terms of why they need to apply for condemnation in that document. So then within that table B that I've mentioned, there's also issues of notification and service. So notification is simply who needs to be known, who needs to know about the application and who needs not to know about the application. But really it's linked to service, which is your biggest thing. Remember, the tribunal is subscribes to natural justice, which means that parties must be given a fair opportunity to present their case. Big deal in that natural justice theme is the idea of serving. So the tribunal has a couple of ways of which you can serve an application. It's found in Rule 30 of the tribunal rules. Rule 30A actually of the tribunal rules, in which tells you how you can serve forms. You can serve forms personally. So if you use a courier, for example, for a personal delivery, that's perfectly fine. Except to say that there needs to be a signature by the person receiving it, because the courier service is not linked to registered mail or anything like that. It's linked to a form of personal delivery or personal service. So make sure that if you're providing a courier slip, that it is actually signed with the courier's instruction to get a signature from the party that you're serving on it. Another way of serving is registered mail. Yes, there's challenges with registered mail in general, in the sense that it sometimes takes a long time for the other party to receive the documents. But in terms of registered mail, the action is yours. The day you serve that document is the day that you get the letter from the post office. That document is what we require when you are filing your application with us. So that is registered mail service. Another form of service, and probably the most utilized, is email service. But when it comes to email service, there's a second step or an add-on step. Before serving by email, you must get consent to service via email. So it's important that someone specifically says, yes, you may serve me via email on this email address. and then you serve on that email address. Both those documents are regarded as service in respect of email service. You can also serve under with fax. It's same as emails, same requirements as email. So when you don't serve an application on someone, or you fail to serve the application on someone, that's where the challenge comes in, because the tribunal can't ascertain whether or not the other person is becoming aware of the matter. So it's quite important that your service is done and you submit your service correctly with your application. If you don't provide a registered mail slip, again, as you go closer to the case and you have provided a registered mail slip, it might be nice to do a track and trace report, which you can download from the post office website, and just add it in so you know whether the person received the documents or not. But remember, the post office service or registered mail service, the effective date at the start of the application is the date in which the registered mail was issued. However, when the respondents or when other parties to certain of these types of applications or any type of applications provide a date of first notification, that date becomes the date that they've received the application. But that's basically on service. Don't forget to click like and subscribe on the bottom right corner of this video. Thank you.